There are governors in Nigeria today that are referred to, or rather, I think a governor that has been referred to as Supreme Court governor for obvious reasons, that he came fourth in the election, but somehow he ended up becoming governor after the Supreme Court verdict. That is just to stress the point that sometimes Nigerians have had cause to really worry about the input of the courts when it comes to elections, where the people's decision does not end up being the people's decision because it is, the court override it. But the question I want to ask is, for Nigerians who are watching the program right now, how do you explain to them, if the law is in black and white about what the rules say, how do you explain the tribunal saying one thing, the appeal court doubling down on that same verdict, and then you have a Supreme Court saying, you know what, you don't know what you're saying. You're making a big mistake. That is an error. Because clearly, I mean, in simple terms, that's basically what they're saying.
That is as normal as normalcy can be. If you are a practicing lawyer, that is not something to talk about anyway. Because most of the time, you see, we lawyers, we are nearer to the facts. Is the law subjective? No, it's not subjective. Listen, we lawyers are nearer to the facts. We lawyers are the composers of the narrative of the cases that we present before the judex. Sometimes you would be emphasizing the point that this is the issue and this is my view on it, you the lawyer, but the judge has his own views on it. Mind you, these are people we all wrote the same exams with. You understand? And we are all called to the bar, the same bar, and we read the same books, we read the same cases. But because he is sitting there as a judge, he has what? A commanding position over that case. But that does not mean he has the final say. After he would have made his own judgment, I would say, oh yes, thank you, brilliant judgment, but I'll go on appeal to re-emphasize what? My own argument, that if you had looked at it this way as I have actually envisioned it, the decision would have been different. The Court of Appeal might say, oh no, 3 of them, or sometimes 5, they could still agree. But you know that you are right. You still now go. I have had to do that many times. And when I get there, they vindicate me, and I come back and say, I was right. Right, okay. You were wrong. Because that's the way the process works. So now, coming back, so that we don't close on the over it. You see, the case of Imo State, Sodiba's case, you see, read the case, read the circumstances of that judgment so that you don't just think that the Supreme Court just whimsically gifted the, the governorship to Hopisodema. Mind you, the Supreme Court is blind to the facts, and is supposed to be blind to the facts. The litigation is for the parties. If I bring my own case before you, you think that my case is frivolous, I do not make any effort to rebut or make a rebuttal. You understand? And I go ahead and prove my case. Mind you, when you go as a petitioner, you are not going to make second and third parties. You are number 4. You're not going to make second and third parties as parties. You go to make what? The person who won. That is the person who has the return, who has been declared a return. He's the person you are going to challenge. If that person now did not do his own homework, and I'm able to prove my case, and I got judgment, you shouldn't say, oh, because what? Second and third are there. But no, it is not the business of the...
Senior advocate, you just talked about the sanctity of the votes.
Yes.
Right?
Yes.
We just talked about the sanctity of the vote.
Yes.
And there is no way we can morally justify...
No, well, you say
based
morally.
On technicality.
Well, at the moment you say morally, I give up. Yes.
But also, not morally. Even the spirit of the law itself. Yeah. Right?
Yes.
That judgment goes against the spirit of the law. Because the law itself is supposed to be just and fair. And there's nothing just and fair in that particular technicality. I mean, I don't want us to really litigate the Imo situation.
No, justice and fairness for the lawyers is what? procedural. It's a procedural thing. It is not a substantive thing that you say, this is Sam Kargbo. It's a person that is Sam Kargbo at all times. No, it's a procedural thing. That's the way we see it.
When it comes to processes, be fair and be just.
The outcome of that procedure, you understand, would actually transmit into justice as long as the parties who have come before the judges are given the fair hearing. Once both parties are given the same opportunities to espouse their own grievances and contest issues, and at the end of the day, one party has what? An upper hand over the other party, justice has been done.
I still think it defeats the purpose of democracy if just because of the technicality of the second runner-up and the third runner-up not being on the case, the fourth person gets to win because he took the case to court. I still think that there's a lot to be said about that.
To avoid that, perhaps we should go to the continental system. The continental system is not adversarial. The judge is not what? Independent, or the judge is not removed from the fray. He's part of the fray.
Into the battlefield.
He gets into the battlefield because what? He is both a finder of facts and a finder of law.